In today's world of work, not everyone is a traditional employee. Many people are hired as independent contractors, freelancers, consultants, designers, or delivery drivers. But what is the difference between an employee and a contractor? It matters for taxes, benefits, rights, and legal responsibilities. A company might ask, should we hire this worker as an employee or a contractor? A worker might ask, am I entitled to benefits or am I just an independent contractor? In this lesson, you'll learn how to explain the legal differences between employees and contractors step by step in clear legal English. By the end of today's lesson, you will use vocabulary like employee, independent contractor, payroll, benefits, tax withholding, supervision, termination, and misclassification. Explain the rights and responsibilities that differ between employees and contractors. You will also practice grammar, present simple versus the present continuous, to describe fixed duties, for example, employees work fixed hours versus ongoing tasks. The contractor is working on a project. You will apply legal phrases such as classify a worker, issue a contract, provide benefits, terminate an agreement. This will help you explain employment status clearly to clients and colleagues. Let's begin with the story. A small tech company in Poland hires a software developer. The manager asks the lawyer, should we hire her as an employee or as an independent contractor? The lawyer explains step by step. An employee works under supervision, follows company rules, and is on the payroll. The employer must provide benefits like health insurance and paid leave. An independent contractor is different. She works on her own schedule, sends invoices, pays her own taxes, and is not entitled to employee benefits. If you classify her wrongly, the company may face legal problems. This is called misclassification. The manager nods. So, if she works long term in our office under our control, she is an employee. But if she works on short projects independently, she is a contractor. This story shows why the distinction is important and how lawyers must explain it in clear, practical English. An employee is someone who works for a company under an employment contract. They follow company rules, work fixed hours, and are usually entitled to benefits like paid leave, health insurance, and pension contributions. For example, the company hired 10 new employees. Let's look at a story. A retail shop hires cashiers. The lawyer explains they are employees. They must follow schedules set by the employer and are protected by labor law, including minimum wage and benefits. Employees are the core of traditional labor law. An independent contractor is not on the payroll. They are self employed, provide specific services, and manage their own taxes. They are not entitled to employee benefits. For example, the company hired a graphic designer as an independent contractor. Let's look at a story. A lawyer explains if you pay a designer for one project and she works from home on her own schedule, she is an independent contractor, not an employee. This status gives flexibility, but fewer protections. Payroll means the system where employees are officially registered and paid by the company, including salary, benefits, and tax withholdings. For example, all company employees are on the payroll. Let's check out a story. A business owner asks, do I need to add this worker to payroll? The lawyer explains, if she is an employee, yes. Payroll ensures taxes and benefits are paid. But if she's a contractor, she issues her own invoices and is not on payroll. Payroll is the key legal line between employees and contractors. Benefits are extra advantages employees receive beyond salary. This includes health insurance, paid leave, pensions, and sometimes bonuses. For example, employees receive benefits like paid holidays. Let's look at this story. A worker compares contracts. Job A offers higher salary, but no benefits. Job B offers health insurance, holidays, and pension. The lawyer explains those are employment benefits. Contractors usually do not get them. Benefits are one of the biggest differences between employees and contractors. Tax withholding means the employer deducts income tax and Social Security contributions directly from an employee's paycheck. For example, the employer is responsible for tax withholding. Let's check out a story. An employee asks, "Why is my paycheck lower than my salary?" The HR officer explains, "Because we withhold tax and pay it to the government for you." Contractors, by contrast, must handle their own taxes. There is no withholding. Supervision means control. Employees work under the employer's direction. They follow schedules, company policies, and orders. Contractors, on the other hand, have independence. For example, employees usually work under close supervision. Let's look at a story. A restaurant hires waiters. The manager decides shifts, uniforms, and behavior rules. The lawyer explains this is supervision. If the worker must follow daily orders, they are likely an employee. Supervision is one of the main tests courts use to classify workers. Termination means ending a working relationship, either an employment contract or a service contract. For example, the contract was terminated after 6 months. Let's take a look at a story. An employee is dismissed for repeated lateness. A contractor finishes a 6-month project and the agreement ends. The lawyer explains both are terminations, but employment law offers employees protections like notice periods and severance pay. Contractors usually just end when the project is over. Understanding termination helps lawyers explain rights at the end of a working relationship. Misclassification happens when an employer incorrectly labels a worker as a contractor instead of an employee, usually to avoid paying benefits or taxes. For example, the company was fined for misclassification of workers. Let's look at a story. A delivery company calls drivers independent contractors, but the drivers wear uniforms, follow strict schedules, and work only for that company. A court later rules they were misclassified. They are employees and must receive benefits. Misclassification is a serious legal risk for companies and a frequent source of disputes. The present simple is used to describe regular duties, rules, or general truths. Example, employees work fixed hours. This describes a typical duty of employees. The second example, the employer provides benefits, a fact about employment. Third example, contractors issue invoices for their services. This is how contractors get paid. Take a look at a story. A lawyer explains to a client an employee works under supervision and receives benefits. A contractor works independently and issues invoices. Notice that all verbs are in the present simple because we are describing fixed roles and ongoing truths, not temporary actions. The present continuous is used to describe ongoing or temporary actions. For example, the contractor is working on a new website project. The work is happening now, but it will finish soon. Example 2. The employee is attending a training course this week, a temporary situation. And the third, they are negotiating a new contract, an action happening right now. Take a look at another story. A company hires a consultant. The manager says she is working with us on a 6-month project, but she does not work for us full time. She is an independent contractor. The present continuous shows the temporary, project based nature of the work, which is typical for contractors. To classify a worker means to legally decide their status, employee or contractor. This classification affects taxes, benefits, and rights. For example, the company must classify workers correctly to avoid legal risks. Let's take a look at an example. A delivery platform calls its drivers contractors. But the drivers, they wear uniforms, they follow schedules, they use company vehicles. And the lawyer warns the company, if you classify them as contractors, it could be misclassification. Legally, they are employees. This phrase is critical because misclassification can lead to fines and lawsuits. To issue a contract means to create and deliver a formal written agreement that defines rights, duties, and terms of work. For example, the company issued a contract to the new employee. Look at a story here. A startup hires a consultant for 6 months. The lawyer explains you must issue a contract for services, not a contract of employment. This makes clear she is an independent contractor. Issuing the correct contract is essential for defining the working relationship. To provide benefits means to give employees extras beyond their salary, such as health insurance, vacation pay, or pension contributions. Contractors usually do not receive these. For example, employers are required to provide benefits to full-time employees. Let's look at a story. An employee compares 2 jobs. Job A pays more but has no benefits, and Job B includes health insurance, paid holidays, and a pension. The lawyer explains only employees are entitled to benefits. Contractors manage their own. Providing benefits, like we talked about before, is one of the clearest signs of employment status. To terminate an agreement means to formally end a contract, either by expiration, mutual consent, or breach. For example, the company terminated the contractor's agreement after the project ended. Let's look at a story. A software developer works as a contractor for 6 months. When the project is complete, the company terminates the agreement. And the lawyer explains, termination for contractors is simple. The project ends. But for employees, termination is more complex, with notice periods and possible claims for unfair or wrongful dismissal. This phrase is key to explaining the difference between employment and contracting relationships. Here are some key expressions used in worker classification cases. Control test. Courts ask, does the company control how, when, and where the person works? For example, the judge applied the control test to decide if the driver was an employee. Economic dependence. If a worker relies on one company for income, they may be considered an employee. For example, her economic dependence showed she was not truly self-employed. Flexible work arrangement. Work that is not traditional 9 to 5. Remote work, part-time, or freelance. For example, the consultant enjoyed a flexible work arrangement. Statutory rights. Rights protected by law, such as minimum wage, safe conditions, or paid holidays. For example, employees cannot waive their statutory rights. Gig economy, which is short-term or app-based work like delivery drivers or ride sharing. For example, the gig economy has created many disputes about employment status. Severance pay. It's compensation for employees when their job ends. Contractors usually do not receive it. For example, the dismissed worker received 6 months of severance pay. These expressions help lawyers explain the tests, rights, and modern realities of distinguishing contractors from employees. Let's finish with the full story. A small marketing agency in Canada hires a social media specialist. The owner asks the lawyer, is she an employee or a contractor? The lawyer explains step by step. First, let's look at her duties. She works regular hours in your office under supervision. That suggests she is an employee. Then let's check payroll and benefits. If she receives health insurance or paid leave, she must be on payroll as an employee. After that, we apply the control test. If you decide her schedule, tasks, and tools, she is under your control. We also ask if she has economic dependence. Does she work only for you? If yes, she's more like an employee than a contractor. So finally, we must classify her correctly. If you misclassify her as a contractor, the company may face fines, back pay, and liability for missed benefits. The owner nods and says, so, if she's working long-term under our direction, she is an employee. But if she was doing a short project independently, she could be a contractor. The lawyer concludes, exactly. Correct classification protects both the worker's rights and the company from legal risk. This story shows how vocabulary, grammar, legal phrases, and key expressions come together to explain worker status clearly to clients. Let's review today's lesson on independent contractors versus employees. First, we practice vocabulary. Terms like employee, contractor, payroll, benefits, tax withholding, supervision, termination, and misclassification. These words help explain employment status clearly. Second, we studied grammar. Present simple for fixed duties. Employees work fixed hours. Present continuous for ongoing, temporary actions. The contractor is working on a project. And third, we used legal phrases. Classify a worker, which is to decide employee or contractor. Issue a contract, which is to provide a written agreement. Provide benefits, which is to give employees health insurance, holidays, etc. Terminate an agreement is to end the working relationship. And fourth, we explored key expressions, control test, economic dependence, flexible work arrangement, statutory rights, gig economy, and severance pay. These are essential for modern labor law. Finally, we told a wrap-up story where a lawyer explained worker classification step by step, using vocabulary, grammar, and legal phrases to avoid misclassification. Now you can confidently explain the difference between contractors and employees in clear, professional legal English.